Welcome to Politics Syndica and Chandran. Today's topic is titled Abbott Government's Refugee Policy Reaching Unprecedented Levels of Barbarism. What is the stand the Labour opposition and the High Court should take? And the importance of this topic cannot be overemphasized. And to speak on this topic, we have Dr. Lucy Fisk and Dr. Joyce Chia. Dr. Joyce Chia is a senior research associate at the Andrew and Renata Kaldor Centre for International Refugee Law at UNSW. She was awarded her PhD on comparative immigration and refugee law at the University College London in 2009. She has previously worked as a senior policy officer at the Australian Charities and Not-for-Profits Commission. She had also worked as a research fellow at Melbourne Law School, as a legal officer at the Australian Law Reform Commission, and as a research associate at the Federal Court of Australia and Victorian Court of Appeal. So please join me in welcoming Lucy and Joyce the usual way.
I'm very glad to be here tonight. I just want to briefly acknowledge that the Andrew Renata Kaldor Centre for International Refugee Law is a very new institution in the landscape. It was established late last year, and I started as a senior research associate in February this year, and my colleague Claire Higgins, who's way down the back, started with me, and it has been a roller coaster ride in refugee policy ever since we started. But today is a particularly exciting day, I think, to talk about the topic, and I'm going to focus on the High Court and the refugees because of the High Court decision that came down today. In a very timely way, I have to say, for this talk, and I've spent most of the day writing an opinion piece about this article, which has just been published minutes before we took off in the car to get here in The Guardian, so I recommend that for reading later on. But I'll talk about that and the current High Court case which is on foot regarding the two boats, well, the one boat, in this case, the 157 Sri Lankan Tamils who were detained on the seas, which will be heard by the High Court in October, mid-October this year. And if I have time, I might also talk about the Cambodia proposal as well. We'll see how I go. I might have to check every now and then to make sure I'm running on track. So to start with today's decision, which is an extremely welcome decision by the High Court, and I think really marks a high point for the High Court in many ways. There were two main aspects to this ruling, and the first one, which was the headline act, I suppose, in the media this morning, was that they effectively said no to the minister's strategy of trying to grant people temporary visas effectively through a legal loophole. And that legal loophole was created when we brought over on a humanitarian basis people from Kosovo and East Timor, so they were given temporary visas for that purpose. They were not assessed as refugees. It was for the limited purpose at that time. And essentially what the effect of the minister granting these visas was to bar them from ever making application for a permanent protection visa. So that was the legal strategy that was being used by the government. And as you can imagine, that put lawyers and people being detained in a very difficult position, because on the one hand, if they accepted these visas that the minister was giving out, they could be released from detention. On the other hand, once they accepted that, they would no longer be allowed to apply for a permanent protection visa. So it was a classic case of sort of making life very difficult for, making those hard choices in your life. Now, what the High Court said today was that that strategy couldn't work because essentially the minister had already started, and this was the previous Labor minister, had already started considering an application for a visa and couldn't then defeat itself by using another provision of the Act. So it's partly about reading the Act consistently, and that was an interesting interpretation of it itself, but the more lasting significance of this case is really what the High Court then said, and it didn't need to say this about detention. And quite remarkably for the High Court, this was a case where all the judges agreed and it was a single judgment. So it was clearly designed as a message, a red flag by the High Court saying we are not standing for this on detention. There are limits to detention. And that is essentially what the High Court, for the first time, very clearly set out in this case. So previously, many years ago, when we had the first round of mandatory detention with, ironically, the Cambodian boat people at the time, the High Court had looked at the validity of this constitutionally and said, okay, it is valid. But that High Court, which was a much more progressive High Court at the time, did set out some boundaries for the limits of detention. And that original legislation was quite different from the legislation that we have now. And one of the key features was that it actually capped the maximum number of days you could spend in detention. And it was actually designed specifically for a designated class. And at the time, didn't apply across the board the way it does now. And that High Court saw two kind of main limits to detention. Essentially, the first main limit was that it had to be for legitimate purpose. And that the majority of the High Court, and that was a split decision which made it a little bit more difficult to rely on, but the majority said, you know, the main purposes that you could use detention for was essentially when you're considering their visa application and when you're removing them. So those are the limits of the detention purposes. And the other, much more controversial limit was that the laws had to be framed in a way where there was a relationship between those purposes and the laws. So that you couldn't, if you weren't actually trying to either consider the visa application or actually trying to remove someone, then your detention became unlawful. And so the High Court said, if it goes beyond those limits, then it infringes essentially what is the hallmark of all constitutional law in Australia and the most effective rights protection mechanism we have, which is the exclusivity of judicial power. That is, it's the role of the judges to decide who gets locked up, who gets to judge, and that is really the limit that they set out in that case. Unfortunately, the composition of the High Court changed over the years, and there were a number of much less satisfactory decisions which effectively never overruled that case, but never really took up those limits in any way. Some members questioned those limits. Effectively, it was seen as a bit of a dead letter. And what was surprising today is that the High Court went right back and wiped that out and said, okay, we're going back to that case in 1992, and we are saying that those limits do apply. And they, for the first time, set out very clearly what those purposes were that were legitimate. And this is quite significant because what had happened in the middle was that a number of the court's justices had decided, had talked about other purposes that might be legitimate. So one of the purposes they said might be legitimate was excluding a person from the Australian community on the basis that person had no right to be in here. So as you can see, that effectively meant you could almost detain them forever, because then that you would be achieving the purpose of excluding them from the Australian community. So that really extended much further than the original decision. But this time the court said no to that. They quite clearly set out three purposes, and those were the only purposes that could be considered. And those were the first two purposes that I've already mentioned, and the purpose of considering whether you'll be allowing someone to make a visa application. Because the quite remarkable thing is, if you land in Australia today, you are actually not allowed to apply for a protection visa unless the minister allows you to do so. So the minister has to personally decide that you can even apply to get a protection visa. So for that purpose, they've been being held for quite a long time. And the High Court had effectively said that the minister could not just prolong that detention sort of indefinitely for that purpose. So the one really great thing is that they said that there are purposes that are limited, that don't extend to excluding people from the community. They also said that there are limits on the duration of detention, so if the minister stops, those purposes must be carried out as soon as reasonably practicable, which means if the minister sort of stops processing people, which effectively we have done now today, then he's no longer detaining him for the purpose under the Act. And that means all the people that we have today in detention, there's a real cloud now over whether they're being legally detained. Because the minister has effectively given up on processing these people at this point. So he's either got to start considering processing these people and resume processing, or he's got to start effectively removing people. And at the moment, these people aren't being detained. And I think the key reason the High Court has finally moved on this is because the practice of detention has become so normalised, but it has also become much more dramatically pervasive in Australian culture. So I did this presentation the other day to a class of students who are interested in forced migration, and the stats from the Department of Immigration's own statistical publications are really very alarming. So we are now up to historic highs of sort of 6,000 people in detention, plus the people who are in the community on bridging visas, of which there are more than 20,000 of those, and the average number of days has gone from sort of 100 to 350 days. And that's an extraordinarily long time to be holding people, and that in part is also happening because a number of people are effectively stuck in indefinite detention and have been for a while. So there are cases of people who have been stuck in indefinite detention for 5, 6 years, and this is an extraordinary practice, and we seem to be in a logjam where we aren't able to get out of it. So I think the High Court was partly motivated by that, but the other reason the High Court has finally stood out, I think, is because this High Court, unlike previous High Courts, I think really recognises the need for the rule of the law in this space. And I think a key role for the High Court, and the High Court, putting it out there, cannot fix the political problem that we've created in refugees. Ultimately, it's up to the political process, but the High Court does play a key role in ensuring the rule of law in this country and ensuring that people are not detained indefinitely at the will of the government without any charge, without any judicial review, which is effectively what the mandatory detention regime allows now. So I think a really important point about the role of the High Court here is that the High Court is meant to be part of the overarching constitutional structure of liberal democracy. Not just majoritarian democracy, but ultimately it is up to the courts to back that up by ensuring that the rights of minorities are preserved in this process. And I think they need to be aware of this, and I think they have increasingly become aware of this, not just in the refugee protection space, which is obviously important, but in a whole range of other areas where more populist laws are coming in, which, for example, the anti-bikies law, which clearly offends some of those liberal principles. And I think that's a really important and quite heartening sign that the High Court has recognised that role in many ways. Which leads on to the question, what is going to do with the next case, the very high-profile case of the 157 Sri Lankan Tamils, which really was an extraordinary time in Australia, I think. The idea that the government could effectively vanish this boat, in fact 2 boats at the time, of people, and not believe it needed to account to either, not only just the people and the media, which it clearly has given up on, but even to Parliament as to what was going on with these people. And I think this is the real constitutional question in this case. So the question now that they've been moved to Nauru is still one about whether they were unlawfully detained. And that raises the real question of whether the government had the power to do what it did legally under Australian law, not just international law. I think on the international law side, that answer is very clear, and I was one of the, I can't remember how many lawyers that signed the petition saying this is not, this is a violation of international law. But under domestic law, the question becomes particularly interesting, I think, because effectively there are 2 ways you could say that that power existed, and one of these was a very obscure act which I did not even know about when this case happened, called the Maritime Powers Act. And the reason this was so obscure is that, like many acts in Australia, it passed very quietly and very quickly. It passed in 2013 under the Labor government, and it was just intended to sort of bring together all existing powers on the high seas, on the seas. And these are pretty extraordinary powers when you think about them. These are powers to search and board and detain people. And effectively, our democratic process is such that the entirety of the consideration by Parliament was really, it went to the Senate Legal and Constitutional Affairs Committee. There were 7 submissions to that committee, of which 6 of which were from government. There was 1 single non-government sort of submission. And there was a single hour of public hearing which entirely consisted of the Attorney General's Department's evidence. So not a single civil society organisation was represented when this Act passed. That was despite the fact that the Act itself, the statement accompanying the Act, quite clearly stated that this could breach Australia's obligations under the Refugee Convention, and quite happily reassured us that that would be solved by some kind of policy and procedure rather than some kind of legislative protection. Now, nobody seems to have ever cleared up whether there was any policy or procedure ever developed, but clearly it wasn't applied by the time the Act finally came into force in March this year. But the interesting thing, particularly interesting thing, we've gone back to the history of this Act, and what is fascinating is that the coalition government, the coalition at the time in opposition, quite clearly thought that this Act removed their power to turn back votes. And there's actually a very good argument for that, and the coalition senator at the time was the former Attorney General of the ACT, and his view, quite clearly expressed, was that this Act would take away the coalition's power to turn back votes. And that is entirely possible, as it turns out, for quite complicated reasons, and I'll try and break it down. But essentially the Act was intended to sort of consolidate all the maritime powers. It does not include a power to turn back votes physically. It does include powers to search, board, examine, as I said, and it does include a power to detain a person and take them to another place, which is the key power that the High Court will be examining. But nowhere does it say that, you know, they can physically tow boats or physically intercept votes in the way that we've been doing since 18 September last year. So there's a very interesting question that then arises, because the only other source of power for turning back votes under Australian law, as I say, is one under the executive power of the Constitution. And the executive power of the Constitution is essentially a power of the government to put into effect various laws, for the most part, and certain sort of nationhood prerogative powers. So based on what used to be the prerogative powers in the UK, and that those had been decided in the very famous Tampa case, way back in 2001, to include a power to exclude people. So it was assumed that that power allowed them to turn back votes. And again, that was a decision that was very controversial, and there were two judges who said yes to that and two that said no, but ultimately the full federal court majority said that there was such a power. But the executive power is a power that it belongs to the government only if the legislation, if the Parliament hasn't legislated on that topic comprehensively. So once Parliament says its say on that matter, any executive power arguably disappears. And that is obviously for a very good constitutional reason. We elect our Parliament, we like to think we live by the rule of the law, and the rule of the law is best served by clearly written laws, scrutinised, perhaps not very effectively at times, by our democratically elected representatives. So there is a very good argument in this case that in fact there is no such power, and that was the coalition's point, which quite rightly made, and they actually tried to pass an amendment to clarify that they had this power, which failed. So we now have a question where we don't actually know if the coalition's Operation Sovereign Borders is legal, which is interesting, and perhaps most fascinating, the person who tried to pass that opposition amendment was our now current Attorney General. So they obviously came into power with doubts about whether turning back votes were illegal, and have made no effort to correct that through the Parliament. So it'll be very interesting to see what happens in that case. And in my view, where the High Court could go, and one of the interesting things is that the Chief Justice of the High Court now was the lead judge on the Tampa decision originally. So we think he's unlikely to say that Tampa was wrong, for obvious reasons, but we do think it's possible, in fact, one very arguable way of getting through it is to say that the landscape has changed. Now we have this Maritime Powers Act, whatever powers there were before under the executive power have disappeared. And the other, I think, really important contextual point is when Tampa was first litigated, we didn't have offshore processing legislation. So we now also have offshore processing legislation, which allows the government to table and designate a particular country to send people off to. And that is obviously not subject to very effective parliamentary scrutiny, but it is a process that goes through Parliament. So the slightly outrageous thing in some ways that I think the government is now claiming is that despite these two pieces of legislation, somewhere there is an unwritten power that they can still detain people on the high seas, even though it's neither authorised by the Maritime Powers Act, arguably, or authorised under the Regional Processing Act. And when you think about that, that seems illogical. Why would you have one act that specifically sets out the procedure to take people to Papua New Guinea and Nauru, and yet claim you have the power essentially to send people back to whichever country you want to without any kind of procedure and any kind of accountability to Parliament? And that raises a really fundamental constitutional question, which is obviously what about the relationship and the balance of power, not between the High Court and the Executive, but really about the relationship of power between the Parliament and the Executive. And what was astonishing to me was that nobody in Parliament seemed to pick up this point during that crisis and say, hang on, we're the democratically elected legislators. Where is your accountability to us? And I think that is potentially where the High Court would find it very difficult to say anything other than that this action was illegal. And so it would be very interesting to see how they come to this conclusion, because there are a number of other ways they could do it, and there was also a suggestion, which is possibly the most minimal suggestion in some ways to get there, which is that the power to detain allows you to take someone from one country to another, but it doesn't allow you to detain someone to the extent where you're leaving them on the high seas for weeks on end. So that simply goes beyond what was contemplated by the Act. So that would be another way of getting to the same purpose. But I do think there's a very strong chance the High Court will find that the actions were illegal, and I think it would be a great thing if they decided so on the constitutional grounds that I've just mentioned, because ultimately that is where I think we need to lay the responsibility, that we need to remember that this is an executive, we didn't elect them, we actually elected the Parliament, and although our legal system often confuses the two, there is actually an important difference between the two. So I think I might have run out of time to talk about Cambodia, but I'll leave that for now and we can touch on that in questions.
Thank you so much.